Strict liability. Definition: one who carries on an abnormally dangerous activity is subject to liability for harm to the person, land, or chattels of another resulting from the activity, even if he has exercised the utmost care to prevent the harm. The risk must be of physical harm to persons to tangible property, and the rule of strict liability is limited to the kind of harm that is abnormally dangerous for persons and tangible property. Essential elements of a tort of strict liability. 1. The existence of an absolute duty on the part of defendant to make the activity or animal safe. 2. Breach of that duty. 3. The breach of the duty was the actual and proximate cause of plaintiff's injury. And 4. Damage to the plaintiff's person or property. Rylands v. Fletcher, 1868. Definition: an activity may be characterized as ultra-hazardous, or abnormally dangerous if it involves a substantial risk of serious harm to person or property no matter how much care is exercised. Whether an activity is ultra-hazardous is a question of law that the court decides. Test: 3 requirements imposed by the court. 1. The activity must involve a risk of serious harm to persons or property. 2. The activity must be one that cannot be performed without risk of serious harm no matter how much care is taken, and it must not be a commonly engaged in activity by persons in the community. 3. The test is based on the landmark case of Rylands v. Fletcher, 1868, LP 3HL 330. Rylands v. Fletcher, 1868, LR 3HL 330. Facts of the case. John Rylands constructed a reservoir on land he was renting from Lord Wilton to supply water to his steam-powered textile mill. Thomas Fletcher operated mines on nearby land where Rylands Reservoir was located, rented from same person. Both have useful users of the land. Rylands, excavating the construction site, came across some disused mine shafts that had been loosely filled with marl and soil. The shafts led a series of interconnected shafts and tunnels into Fletcher's mines and land. On the 11th of December 1860, just one day after the completion of the reservoir, water from Rylands Reservoir flooded into Fletcher's mines and partially filled. Fletcher sued Rylands. Court proceedings. Rylands succeed on the ground. Trespass required direct human involvement in the invasion of an interest, the quiet enjoyment of land, and this requires intent or negligence. Rylands had been engaged in a reasonable and lawful act, with no ill intent or negligence, and there was no nuisance as there was nothing offensive to the senses about water. Appellate forum. The prior decision was overturned in favor of the appellant Fletcher. The issue before the court was whether the doctrine of strict liability could be applied to inherently dangerous activities in the same way as was applied in nuisance and cattle trespass. Justice Colin Blackburn said, "We think that the true rule of law, that the person who for his own purposes brings on his lands and collects and keeps there anything likely to do mischief if it escapes, must keep it at his peril, and if he does not do so, is prime facie answerable for all the damage which is the natural consequence of its escape. He can excuse himself by showing that the escape was owing to the plaintiff's default, or perhaps, that the escape was the consequence of vis major, or the act of God, but as nothing of this sort exists here, it is unnecessary to inquire what excuse would be sufficient." Rylands appealed to House of Lords. The appeal was dismissed and agreed with the determination for Fletcher, adding a further limitation on liability to the effect: the land from which escape occurs must have been modified in a way which would be considered non-natural, unusual, or inappropriate. The rule was later extended by courts to other types of ultra-hazardous activity like blasting, manufacturing explosives, crop dusting and fumigation.